We have a small class today, which is a good thing because that leaves a lot of time for questions, and I can give, a lot of individual answers. If it starts to get noisy in your house, if someone starts clattering around or you get a phone call, please put yourself on mute so that everyone is not sharing your conversation or your noise. So I'm going to welcome you. And today we are going to be talking about elder law, and the actual name for this presentation is the Elder Law Workshop. My name is Ellen Makovsky. I am an elder law and trust and estates attorney. My practice is located in Garden City, and I have been involved in elder law since the early 90s. And I have been the president of the National Academy of Elder Law Attorneys in New York. I've served as the chair of the New York State Bar Elder Law Section. I've served as the president of the Elder Law Council, and I have been named a top 50 woman super lawyer in the elder law category. So my colleagues think I know what I'm doing. And I hope at the end of this presentation, you will share their view. When I sent you the Zoom invitation, there were some attachments to that email. And I attached a healthcare proxy for you. I attached a power of attorney form, and I attached the numbers in regard to the Medicaid eligibility rules. So we're going to be discussing all of those, and you can download and print out those documents at a later time when it's more convenient for you. So let me start off by talking about elder law. What is elder law? And I'm going to say that today is May 4th, 2021. These laws and statutes and regulations change. What I'm talking to you about today is New York law in 2021. So when we talk about elder law, we're really talking about answering 4 basic questions. Who will make healthcare decisions for me if I'm unable to make my own decisions? How can I put somebody in place to make financial decisions for me if I can't make my own financial decisions? A big question for so many people is, how will I pay for long-term care? And then the last element of an elder law practice is really, how do I leave assets to heirs? And we're going to talk tonight about the first 3 questions, and I'm going to leave the explanation of how to leave assets to heirs for another program. We're just going to touch on it very, very tangentially. So let's start off with a discussion of how to put somebody in place to make healthcare decisions for you. And in New York State, we have a number of different ways to accomplish this. We have the healthcare proxy. We have the medical order for life-sustaining treatment. We have living wills. We have the Family Healthcare Decisions Act, and we have do not resuscitate orders. And let's talk about each one of these. The best way to put somebody in place to make healthcare decisions for you is actually the simplest way, and that is the healthcare proxy. And a healthcare proxy is a form that appoints somebody to make medical decisions for you only in the event you cannot make your own medical decisions. And the doctor makes that determination about capacity, whether you have enough capacity to make your own decisions. If the physician determines you lack capacity, Your agent then has the power to basically step into your shoes and act for you. And the agent, under the New York State healthcare proxy law, can make any decision regarding your healthcare that you could have made. What doctor, what hospital, what kind of treatment, how aggressive that treatment should be, and end-of-life decision-making. But the healthcare proxy is not only an end-of-life decision document. It's for throughout your lifetime when you cannot make your own medical decisions. The agent under the healthcare proxy law is required to act according to your wishes and your directions. When the agent doesn't know exactly what your wishes are, there's what's known as the best interest standard. What would be in Joan's best interest, except when it comes to artificial nutrition and hydration, where the agent has to know exactly what you want. And we're talking here about food, tube feeding, where the agent has to know exactly what you would have wanted. Under the healthcare proxy law, you can only appoint one agent to act for you at a time. The hospital does not want to be in the position of daughter number one saying something and daughter number two saying something else. So right in the legislation, it says you can only name one person to act at a time. And you can name a substitute agent who has the ability to act if the initial agent is unavailable or has died or predeceased you. In thinking about who your agent should be, you need to choose somebody who is going to act according to your wishes and not their own interests and beliefs or their own, you don't want them to do what they would do for themselves. You want them to do what you've instructed them to do and what is in your best interest to do. You want to choose somebody who has the emotional strength to make a difficult decision. You want to choose somebody who is available to make the decisions, who's going to be able to talk to the doctor, who's going to be able to call the nurse and find out how you are that day, and who's going to be talking to you and visiting you if that's a possibility. So in the healthcare proxy document, you are appointing the person to act for you. And after this presentation is over, if you take a look at the sample healthcare proxy, you're going to see that there is a space for optional instructions that you can give to your healthcare agent. And I try to have my clients write very little in the optional instructions. There's only one really important thing that needs to be written in the optional instructions. And if you're taking notes, this is the time to copy the phrase down, because I've given you a sample healthcare proxy that after this presentation, you can print out and you can fill out and you can sign in front of two witnesses, and you're going to walk out with a healthcare proxy that works and is valid. So for optional instructions, I suggest that you write down, my agent and my successor agent know my wishes in regard to artificial nutrition and hydration. And the law requires that the agent know what those wishes are. I don't like to write down the specific wish, because the beauty of a healthcare proxy is you have a living, breathing person with a brain to make decisions for you according to the situation that you find yourself in. A 20-year-old has a very different idea of what is tolerable as far as healthcare than an 80-year-old has. And your particular health prognosis and situation may change. And you're going to pick a trusted agent to comply with your wishes. And you need to talk to the agent before you appoint them to make sure you are appointing the right agent for yourself, who's going to make decisions for you in conjunction with what your wishes are. Do any of you have any questions about healthcare proxies?
Yes. Can you have more than one successor?
Uh,
Like what if I put my husband and then one daughter, then another daughter? I mean, can you just keep going on and on?
My suggestion is that you only name your agent, your husband and one of your daughters, and then if your husband or your daughter, something unexpected happens to them, it's a very easy form to redo. The
Okay.
simpler these forms are, the more readily they are accepted. And if you name both of your daughters on the form, you're going to have an invalid form because you can't have people acting together pursuant to the statute.
Right. I
Okay.
thought you could say.
Move forward.
Sorry, Ellen, where do you indicate that my agent knows my wishes in regards to the nutrition?
Where it says optional instructions, there's a spot in the document. I don't have it in front of me.
I
but I-
download, I have
What?
everything here. I
Yeah.
downloaded everything, so.
Yeah.
So it's already printed on here, or you have to?
It says
write it?
optional instructions, and that's where you fill that in.
Okay,
I only have an hour, so I want to move forward. I promise you it is there. It's more
okay,
than one page form. And if it's not, you can call me afterwards.
that's okay.
So the next document that we have for surrogate healthcare decision-making in New York State is a living will. And a living will is not actually recognized by statute in New York State. We have the healthcare proxy law, but it will be recognized as evidence of what you would have wanted. And it is recognized by common law in the courts after they hear testimony. If there's any controversy over the actions of the person who is following the living will. So, and what a living will is a statement that attempts to anticipate what kind of medical circumstance you will be in the future at the end of life, and describes what medical treatment you want or you want withdrawn in a particular situation. So a living will says something like, if I am unconscious with no hope of recovery and I have an incurable disease, I do not want artificial nutrition and hydration or extraordinary means taken for me. But it only fits a narrow range of circumstances, in contrast to the healthcare proxy, where the agent can make any medical decision for you. Also in New York State, we have medical orders for life-sustaining treatment. And this is a form that you fill out in conjunction with the guidance of your physician or some other healthcare professional. It's typically used when somebody has some sort of degenerate disease or cancer, and there's going to be a long path of treatment for that person. And what happens is the physician will go down the form and explain all the alternative treatments that the person might get and the pros and cons of getting that type of treatment. And then the person who is filling out the most will decide whether or not they want that treatment in advance and in what conditions. It centralizes all life-sustaining treatment. And when you fill it out with your doctor, it follows you from the home to the hospital, to the nursing home, to hospice, or wherever you find yourself. And you'll know you've signed a mulct because part of the statute of the mulct says it has to be printed on a bright pink form so that it can be easily found by those who need it. Everybody knows what it is. Now's the time to go on mute if you're going to answer it. All right, so let's talk now about the Family Healthcare Decisions Act. This is a rather recent statute in New York State, and it was put in place for those who are in a hospital or a nursing facility and never executed a healthcare proxy. And what it is there is a prioritized list of surrogate decision makers, starting off with a person's guardian, going to their spouse, going to their same-sex partner, and down to children, et cetera, and it comes all the way down to a friend. The person who is at the top of the list is the person who gets appointed to make healthcare decisions for you. It's good to have somebody who can make healthcare decisions for you, but the person who's at the top of the list may not be the person you would have chosen had you done your own healthcare proxy. But this is a very good backstop, so at least somebody can make decisions for you. And this is called the Family Healthcare Decisions Act. And then finally, we have DNRs, or do not resuscitate orders. So in New York State, and I think in every state in the United States, there is a presumption for resuscitation. Physicians and healthcare personnel have to come running when you are in respiratory distress or you're in cardiac arrest, and they have to do what they can to resuscitate you. It's part of their ethical code. And this can result in a very aggressive action in trying to bring somebody back to life. You know, we've all seen on TV when they do the code blue and everyone comes rushing into the room and they start pounding on your chest and using those defibrillators in order to bring you back. Often when this is done, when a person is at the very end of life or is very frail or has gone through a very long illness, maybe they will get the person revived, but often the person comes back, they've lacked oxygen for a period of time and they never come back as the person they were before the resuscitation. So we have what are known as do not resuscitate orders, where you can give the medical personnel permission to stand back and do nothing if you go into cardiac arrest or you have a respiratory problem. A DNR is different from the healthcare proxy, the living will, because it is not a lawyer-generated document. It is a doctor-generated document. So nobody comes into my office and gets a DNR. You get a DNR when you go and visit your doctor or you're lying in the hospital bed and somebody approaches you or will approach a family member asking if they want to authorize a DNR. When you have somebody who is at home and goes into cardiac arrest and the EMS comes to try to save that person, even if the healthcare agent under the healthcare proxy is in the room, they can't overcome the presumption for resuscitation, and the EMS is going to be pounding on the person's chest unless there is a DNR someplace in the house that can be shown to the EMS crew. So that's a do not resuscitate order. Does anyone have any questions that I can answer?
Just one question. Does any of this have to be notarized or filed anywhere with?
Well, the DNR is a doctor-generated document, so that is for the doctor to sign off, and no, that is not notarized. And DNRs in a hospital, I believe, last for 3 days before they have to be reauthorized. A DNR at home, I believe, will last for 60 days, and then the doctor has to reauthorize it.
Oh, my gosh.
A healthcare proxy is a document that the New York State Legislature wanted to make a very simple document that every citizen of of New York State could sign and use. And they've made the process for doing that very simple. So you sign your healthcare proxy in front of 2 witnesses. Better that they are not related to you. A neighbor or friend is a very good witness, and they're just signing and saying they saw that you signed it. They're witnessing that you signed it. There's no notary required, and there's no lawyer required to do it. I do healthcare proxies for pretty much for every client who comes in and does documents, because I think it's a really important thing for everyone to have. And when somebody has nobody to appoint as their agent, then we will do a living will. A living will typically is signed by the principal, and it's often notarized, but there's no specific requirement for that. But the healthcare proxy is really easy to do. Your 3 friends, you can just fill it out tonight, and tomorrow when you go to work, have a healthcare proxy signing party over the water cooler. It'll be the talk of the office.
Yeah.
All right, let's talk a little bit about financial decision-making. How do I put somebody in place to make financial decisions for me if I am unable to make my own financial decisions? And in New York State, we have 3 methods of doing that. We have the power of attorney, we have revocable trusts, and we have guardianship proceedings. And let's talk a little bit about each one of these things. So in New York State, we have powers of attorney. And this is a document where you can appoint 1 or more persons to make financial decisions for you. And you can allow those individuals each to act separately, or you can require them to act together. You can also name a successor agent under the power of attorney. When you execute the power of attorney, you sign the power of attorney, you authorize the agent as to the specific things that they can do for you, the specific financial powers. Each has to be authorized by a signature. By initials that you are agreeing to give your agent those powers. There are most powers of attorney that we do in New York State for estate and disability planning. Not most, but all of them are durable, meaning the principal, the person who has created the document, is going to say that the power of attorney survives their incapacity. So if they become incapacitated, the agent can continue to act for the individual. That's what a durable power of attorney is. For my clients, I always have them do what are known as presently exercisable powers of attorney, meaning they don't spring into effect at some later date. The moment the principal signs the document and the agent signs the power of attorney, the agent has the power to act as to those powers that the principal has given the agent. I find that springing powers of attorney are not very useful because that's really when you want your agent to act, and they only spring into effect if the agent can prove you're incapacitated. And I found that doctors are very reluctant to sign statements saying that you lack capacity when they feel they'll be responsible if your daughter goes into your bank account and removes assets from it. So they're very problematic. If you do not trust the person that you are appointing as your agent under the power of attorney, that is not the suitable agent. You have to appoint somebody in whom you have explicit confidence. And if you want, and most people are appointing their spouse, or if they're not appointing their spouse, they're appointing their children, and they can require their children to act together. But you have to give them the present power to act in regard to the document. So in New York State, the power of attorney is on a statutory form. The language of the power of attorney has to be exactly as it appears in the form. There are powers that can be added to the form, but you can't take any of the language out of the form. I think I've already said who the players are for the power of attorney. We have the principal, that would be you, the person who creates the power of attorney, and the person who determines what powers the agent is going to have. And then you have the agent, the person who is given the power to act on your behalf. The current power of attorney form is a two-part form. The first part of it has everyday powers, and actually on the pre-printed form, there are powers listed A through O. And if you agree to all of those powers, you can just initial the power P on the form. And these are everyday powers like the power to do your banking and sign your checks, the power to deal with your insurance policies, the power to take care of your stuff and your things. There's a whole listing of powers that you can grant your agent. And then there are additional powers that can be put onto the power of attorney that don't go to gift giving, like the power to deal with your real estate and at your specific address. There are all sorts of different powers that the attorney might want to put into your power of attorney form. The second part of the current form is what's called the Special Major Gifts Rider. And this allows the agent to make gifts on your behalf. So on the everyday powers part of the form, gifts are limited to $500 in any particular year. In the Special Major Gifts Rider, you can enlarge the gift giving power. And this is the part of the power of attorney that the attorney will also often suggest that you use if you want to leave an avenue to do Medicaid planning in the future. Remember when you, or not remember, but I'm going to tell you, in order to be eligible for Medicaid, you have to have very little in assets. And you have very little in assets by either spending down all your money or giving it away in some way to make you eligible for Medicaid. So those powers can be added to the gift rider on the power of attorney. And we also use gifts to reduce estate taxes. So that's an important power. For the power of attorney, it's not, the power of attorney doesn't come into effect until both the principal has signed the power of attorney and the agent you are appointing to act also signs the power of attorney, affirming that he understands his or her duties and responsibility. The principal has to sign in front of a notary and 2 witnesses for the gift writer, and the agent needs to sign in front of a notary. All that said, this particular power of attorney has been in force and effect for the past 11 years. But on June 18th of this year, 2021, there is going to be a new, simpler power of attorney form, which is going to be easier for the principal to understand and use, I believe, than the current form. So if you're thinking about executing a power of attorney, you can take a look at the power of attorney I gave you in the sample. But the new power of attorney is going to be a much easier form to deal with. And you might want to hold off until June 18th before you sign a new power of attorney. Are there any questions about powers of attorney? Because I want to go on to the next, which is revocable trusts. So revocable trusts are used for estate planning, but today I really want to talk about them in the context of disability planning. Because what a revocable trust does is it provides for the management of whatever trust assets it owns during your lifetime, and then it distributes those assets at death. So revocable trusts are constructed so that they have trustees and successor trustees, and the successor can step in at any time. Who are the players for a revocable trust? And a revocable trust is basically, it's a contract, and it sets forth what is going to happen to those assets that are owned by the trust. The settlor is the person who creates the trust and the person who funds the trust. So that would be each one of you. The trustee is the person who has legal title to the assets, who can invest the assets, and who is responsible for following the rules that the settlor, you, have set down in the trust. So initially, in most trustees, in most revocable trusts, you would be your own trustee for a revocable trust. That's allowed in New York State. And then you name a successor trust, again, to step into your shoes if you become incapacitated. And if you become incapacitated, the trustee has all the powers that you would have had. So they can totally control your finances. They can sell your house. They can buy a new house for you that's more commensurate with what your new needs are. They can purchase an apartment for you. They can invest your portfolio in stocks and bonds or CDs or whatever you think you want to instruct your trustee to do. So that's the settlor. We have the trustee, and then we have the beneficiary. So when you initially create this revocable trust, you are not only the settlor and the trustee, you are also the beneficiary of your own revocable trust. And the rules set down in the trust are going to be all of the assets of the trust are to be used for the benefit of the settlor, and all of the income is going to go to the settlor. And then you set forth a second set of instructions which say, well, at my death, these are the beneficiaries. And you can make that listing of beneficiaries as simple or as elaborate with more instructions as you like, as part of the revocable trust. The tricky part with revocable trusts is that the trust must be funded. The trust only controls and distributes those assets that it owns. So once you've created this revocable trust, you have to take the second step of funding the trust, which means you need to do a new deed for your house. So instead of Mary Smith owning the house, Mary Smith, as trustee of the Mary Smith Trust, now owns the house. It's the creation and filing of a whole new deed that makes it so that the trust owns the house. All your bank accounts have to be retitled into the name of the trust. And similarly, any brokerage accounts have to be retitled into your trust, because the trust only controls those assets that it owns. If you become disabled and your successor trustee is taking over, they can do anything that is required for your well-being as the trustee. And that's why trusts are often used in connection with financial planning when you need somebody else to do it for you. So what happens if you become incapacitated and you never got around to doing a power of attorney, and you never got around to doing a revocable trust, or you created the revocable trust and you forgot to fund the revocable trust? What happens when you get really sick? You can't take care of your own finances, you can't access your own finances, and nobody can pay your bills because there is no plan for surrogate financial management. So then what we need to do is a court proceeding. A court proceeding is a guardianship proceeding. And this is something that everybody should want to avoid, because guardianships are public court proceedings. Your finances become part of the court record. Your family members are notified that you require a guardian, and they learn all the details about your life. It's a lengthy proceeding that can take months and months. It is expensive because you are paying there's the attorney who brings the petition for guardianship against you. There is the court evaluator who is appointed by the court to investigate whether or not you should have a guardian. You can have your own attorney if you're objecting to the guardianship. And when the whole thing is over, months and months later, the court typically will award all of the legal fees from your own finances. So you wind up paying for everybody's attorney in a guardianship proceeding. And then at the end of the whole proceeding, the court may appoint some attorney or social worker or some stranger to be your guardian, and doesn't appoint a family member to be looking after you. So guardianships are really something to avoid, and it's so simple to do with a power of attorney or a funded revocable trust. Do we have any questions? Okay, so let's go on to long-term care. We're going to talk about what is long-term care, what everybody wants to know, how do you pay for long-term care, what type of Medicaid programs provide long-term care. We'll talk about the eligibility criteria for Medicaid. And then, of course, what everyone wants to know is how do I become eligible for Medicaid if something really disastrous happens to me? So let's go through those things. And let's first talk about what is long-term care. When somebody is said to require long-term care, it means that they need custodial care or help with the activities of daily living, such as bathing, eating, mobility, transferring from bed to chair, or people who are incontinent are said to require long-term care. Those who have cognitive problems also require custodial or long-term care. That's what we're talking about here. We're not talking about acute care. And there are a variety of ways to pay for this long-term care. The first is private pay, which is what nobody wants to do. Private pay for long-term care is very expensive. If you're going to get a home health care aide in the house for 24/7, it's going to wind up costing something around $2,000 a month. And that does not include what you're paying for rent or the upkeep on your home and the support of your spouse. If you need a nursing home, nursing homes in the metropolitan area cost between, I would say, $16,000 and $18,000 per month. You can stay at the Ritz-Carlton and probably pay less than that, and it's a lot more fun. Long-term care is a very expensive proposition. Another way to pay for long-term care is with long-term care insurance. And this is a product that will pay for your care at home or in a nursing home if you meet the requirements of the policy, and typically you have to not be able to do 2 to 3 of the activities of daily living in order to trigger the policy. There are quite a number of older long-term care insurance policies out there. When they were originally envisioned, the actuaries didn't figure out what the premiums should be so well. The thought was, oh, people will take out these policies, they'll get tired of paying the premiums, they'll drop the premiums, and we'll use those monies to pay out the benefits. But that didn't happen. And many, many people have triggered their long-term care insurance. And as a result, many insurance companies who formerly were offering long-term care insurance have pulled out of that market. And the current long-term care insurance policies have become very expensive. If you have a long-term care policy, I am urging you not to let it go. It's very valuable, even though the premiums appear to be expensive to you. Let's talk about Medicare, because many people think that Medicare is going to pay for their long-term care needs. And Medicare only will pay for long-term care in a very narrow range of circumstances, because Medicare is for acute care. Medicare will pay for long-term care. They will pay for days 1 through 20 in a nursing home if you require some component of skilled care. And typically somebody who goes from a hospital into a rehab facility or into a nursing home requires some sort of physical therapy, and that will qualify as skilled care. And Medicare will, and there are other skilled care needs that rehab facilities provide, but physical therapy is the most common one. And if you require that physical therapy and you can participate in physical therapy and therefore are getting skilled care, Medicare will pay for days 1 through 20 in the rehab facility. Days 21 through 100, they will require you to pay a copay. And if you have a Medigap insurance policy that wraps around your Medicare benefits, you can get full coverage because Medicare will pay for days 1 through 20 in full. Days 21 through 100, Medicare will pay, and your Medigap policy will pay the copay up to day 100. Day 101, you're on your own. Medicare will also pay for some very limited hours of home health care, typically 2 to 4 hours a day, a few days a week when you're initially released from the hospital. But after that, you're on your own. There are some veterans benefits, but basically veterans benefits do not pay for nursing home care unless you're in a nursing home because you are wounded in active duty. And so that tends not to fit most of my elderly clients. There is a very useful benefit that the VA provides. It's called aid and attendance. And it's actually a pension of sorts for an elderly veteran or the veteran's widow. And if you have very little in assets and very little in income, this program, which is called Aid and Attendance, is very helpful. And I often use this aid and attendance when I have the situation where somebody has been in assisted living for a number of years, and they've gone through their assets, and they're basically left with Social Security and maybe a small pension. And often we can, if they meet the right criteria, we can apply for aid and attendance, and the payment from the aid and attendance plus the Social Security and some small pension will pay for the room in the assisted living facility. So I found that to be very, very useful. So if you have a neighbor or a family member that this might help, you might mention aid and attendance to them. And then the last way we pay for long-term care is through the Medicaid program. And Medicaid is different from Medicare. Medicare is an insurance program. You pay in during your working life. You get to be the right age. You have the right illness. Medicare will provide you with very good coverage, but again, mostly for acute care. The Medicaid program is not an insurance program. It's an entitlement program. And you have to have very little in assets and income in order to be eligible. It was envisioned as a safety net for those people who had no way to pay for their healthcare insurance. And actually the Medicare and the Medicaid programs were dual legislations. They were signed back to back by President Johnson back in the 60s. Medicare was the insurance program, Medicaid was the entitlement program. But in the 60s, the average lifespan, I think, when this was signed was 67 years old. Today, it's 82 years old as the average lifespan. So what has happened is you have many, many middle-class people who are living longer and longer. They're not always that healthy. And they wind up applying for Medicaid benefits because they can't pay for their own health care and support their families. So let's talk about the different kinds of Medicaid programs. And here I'm only talking about long-term care. So we have two basic programs. We have Community Medicaid, which is basically a program that provides help in the house. They will provide a home health care aid in the house. They will help you with adult daycare so a person can go out. They will pay for different services that will come to your home that will help maintain you at home in a safe way. And then the other program for long-term care is the nursing home program. And that is exactly what it sounds like. Medicare will pay for your stay in a nursing home if you meet the eligibility criteria. So let's look at that a little bit more carefully. So I've given you these numbers in the materials that I gave you. So in order to be eligible for Medicaid, you can have no more than $15,900 in assets. So in Medicaid speak, they're called resources. It's not income, these are assets. Medicaid is very generous. There are certain things they will let you keep over and above that $15,900. They will allow you to prepay for your funeral in a Medicaid irrevocable burial trust, and they will not count that as part of your $15,900. They will allow you to buy your own cemetery plot, and they won't take it away from you as part and saying that this makes you ineligible for Medicaid benefits. They do not count your residence under certain situations, which I'll discuss with you in a moment. They do not count certain retirement plans as part of your assets, and they do not count certain annuities. With the annuities, they don't count them as long as you make Medicaid the ultimate beneficiary of the annuity. So we don't do too much with annuities in regard to Medicaid planning. But a house is often one of the largest assets that an individual owns. So the house exemption is a really important one. And a house is exempt from consideration as your asset as long as the Medicaid recipient is living in the house or has an intent to return to the house. So what this means is Medicaid can never take your house away from you while you're living in it. Medicaid considers the house an exempt asset as long as your spouse is living in the house. So the spouse can live in the house 20 years after you've had Medicaid. Medicaid can't touch that house. Where you have a brother or a sister, a sibling with an equity interest who's residing in the house, the house is exempt. This is a situation where brother and sister inherited the house from mom, and they're still living there 30 years later. However, when the exemption no longer exists, meaning you were living at home and now you need to go to a nursing home and you lived alone in the house is no longer exempt, and Medicaid can place a lien on the house for the amount of money that they spent on you once the exemption is no longer there. When let's say the husband is in the nursing home and the healthy spouse is residing in the house, it was an exempt asset. If the healthy spouse dies first, and that happens, Medicaid is going to put a lien on the house for the amount of money that they spent on the sick spouse. So we do a lot of planning with houses. And one of the things that we often do is we will take the house and we will place the house in a trust, different from the trusts I described previously, because now we are talking about irrevocable trusts that cannot be changed or amended. And you cannot get the house back once it goes into the trust. But the trust will allow you to live in the house for the rest of your life. Medicaid will never get that house. You will continue to get, in a properly constructed Medicaid trust, you are step up in basis in the house so that there's no capital gains to be paid when the house is sold, and you will continue to get the reductions you are currently getting on your real estate taxes in one way or another. Placing a house in a trust is a very good way to hedge your bets against Medicaid, because when you take this house and you place it in this Medicaid irrevocable trust, you still have the complete right to live in the house. The house can be sold. The money, the proceeds from the sale can be used to buy another residence for you, which continues to stay in the trust. And you never feel it, because most of us are not consuming our homes to live. We're just living in them. And you're taking a big asset off the plate that Medicaid can never touch. So that's what we do with the house. Retirement plans are also assets that Medicaid does not count as long as they are in payout status, meaning you are taking your minimum distribution from from the retirement, from the IRA or the 401k or whatever retirement plan you have. So Medicaid won't count that. So Medicaid won't count that $500,000 house as long as you're living in it. And Medicaid won't count that $500,000 retirement account you have, but they will count the minimum distributions from the IRA as part of the income that you receive. And we need to do additional planning with that income, which we can do. And Medicaid can only take a portion of the minimum distributions from the healthy spouse, if that healthy spouse has a retirement plan. So as far as resources, there is often a lot of planning that we can do, and we can shelter the retirement account, we can shelter the house, and we can shelter $15,900. And then we have to figure out what to do with the rest of the assets that you own. Not only does Medicaid limit the amount of resources that you can have, but there are also limits on the amount of income that you are allowed to keep. And an individual in 2021 in New York State can keep $884 plus $20 if you are older than 65 and you're on the community home care program. If you are in a nursing home, you can keep $50, which is called your luxury account, which pays for your haircut and your cigarettes if you're still smoking. Any excess income above the home care amount of $884 or the $50 for the nursing home limit is supposed to go to the provider of care to reduce the cost of your care for Medicaid. However, if you are receiving community Medicaid, we can shelter your excess income in a special kind of trust called a pool trust, where every month your excess income above the $884 is deposited into the pool trust, and you can draw down on that pool trust to pay your expenses while you're living home. Cannot do this for nursing home care, but you can do it for the community Medicaid. There are more planning opportunities for somebody who's married. So when you are a married person and you have a healthy spouse living in the community and you are in the nursing home, that healthy spouse is called the community spouse. And they are allowed to keep additional assets over your $15,900. And the actual amount is figured out by formula. And it ranges between $74,820 and $130,380. Additionally, the community spouse can keep income of $3,259.50. They come to this number by formula. And this year we have cents added to it. All excess income is supposed to be spent down, again, to reimburse Medicaid for the care that they have provided. So here's the all-important question: how to become eligible? The obvious way to become eligible is to spend down your money on your health care. You spend, you spend, you spend. When you have $15,000 left, you make the application for Medicaid, and Medicaid will be approved. Of course, you will not have enough money to remain at home because who can live in Nassau County on $884 a month with nothing to pay as far as principal? You can also become eligible for Medicaid by making transfers. And making transfers means making gifts of your assets to become eligible for Medicaid. When you go to make a Medicaid application, you have to hand in to the Department of Social Services, when you're making an application for nursing home care, all of your financial records going back for a period of 5 years. And you have to explain the deposits and withdrawals in excess of $1,000 as part of your application. So you can say, I spent $8,000. I recarpeted my home and I bought some new rugs. I spent $20,000. I rented an apartment, a condo down in Florida for the winter. But as soon as you say, I gave $15,000 to my daughter, Sue, and $15,000 to my son, Scott, Medicaid says, aha, you made a gift. We can't stop you from making gifts, but we can penalize you for making those gifts. And the way they penalize you is there is a period of time, if you've made a gift, where you are ineligible for Medicaid benefits. So if you've made a gift prior to the application for Medicaid in a nursing home, within the 5-year look-back period, they apply a formula to determine how long you are ineligible for Medicaid benefits. And they take the amount of the gift, they divide it by the average cost of the nursing home in the particular county, and that gives them the number of months you are ineligible for benefits in a nursing home. The penalty period does not begin to run until you are already in the nursing home, have made an application for Medicaid benefits, and you were denied because you made a gift. So you could have made a gift 4 years ago. And if you need Medicaid services today, the penalty period is only beginning to run today, not from 4 years ago. So in the example I gave you just a few minutes ago, I gave $15,000 away in this fictitious gift to Sue and $15,000 to Scott. And if I'm going to divide it by the number they are using in Nassau County in 2021, $13,834, that is going to give me a 2.16 month penalty period, where you're going to have to pay privately in order to be eligible for Medicaid. So it can be very, very tricky. However, there are certain gifts that can be given without having a penalty period imposed. Under the current law, if you make an application for community Medicaid, care at home, you can give everything you have away today. We're on March 4th. We're at May 4th. And if on June 1, you have only $15,900 and you make an application for Medicaid, under the current law, you are eligible for Medicaid without a penalty period. Most people would prefer home care. If you are a married person, you can transfer everything you own today to your spouse. And if on June 1st, 2021, you only have $15,900, you are eligible for Medicaid. Remember, often to make these transfers, when you have a person who is very disabled and very sick, you need a power of attorney. That's why the power of attorney can be so important. There are also certain transfers of the residence that can be made where there is no penalty period. So if you have a child who is living in the house with you and has lived in that house for 2 years prior to you entering the nursing home, you can transfer that house to that child, who Medicaid calls the caretaker child, with the idea that they kept you out of the nursing home for those 2 years and they shouldn't lose their residence. So that is another penalty-free transfer that can be made. And we have lots of different techniques for shortening penalty periods depending upon the situation that you find yourself in. When you are a married couple, it is relatively simpler to become eligible for Medicaid. And most married couples where one of the two spouses makes an application for Medicaid here in Nassau County is done pursuant to spousal refusal. So remember, I told you an individual is eligible for Medicaid when they have only $15,900 in their name. Transfers between husband and wife incur no penalty period. So husband can give all his assets or all the joint assets to the healthy spouse. The healthy spouse will likely have more assets than they are allowed to have under the current regulations. However, in New York State, the spouse can refuse to contribute excess assets for the care of the sick spouse. And that is done in a formal writing known as spousal refusal that is submitted with the Medicaid application when you're making the application for the sick spouse. This is the way most married couples will get one of the pair onto the Medicaid program. The Department of Social Services maintains the right to sue that refusing spouse for spousal support, but they are currently not doing this, and they haven't done it for quite a number of years. So this is a viable way to get Medicaid benefits for the sick spouse. Now, I said to you just a few minutes ago that you can transfer everything away. And if on the first day of the month, you only have $15,900 in your name, you are eligible for community Medicaid because there are no penalty periods imposed for community Medicaid. That is true today. But in the Governor Cuomo's budget in March of 2020, not this past March, but the year before when COVID had just started. In that budget is a provision to impose a 30-month penalty period. I'm sorry, a 30-month look back period for community Medicaid, meaning they will have 2.5 years to look back and see if you've made any gifts during that 2.5 year period. And then if you've made gifts, they can impose a penalty period during which time you'll be ineligible for home care. So this was put into the New York State budget. It was supposed to come into operation in October of 2020. Federal regulations override New York State regulations. And as a result, the federal of those rules, the implementation of these new rules were pushed back to January 2021. They were pushed back again to April 2021. And the latest information that I have is that nothing is going to happen with this until January 1, 2022. So we have to see whether this is going to be implemented. However, if you know anyone who is thinking about community Medicaid and is thinking sometime in the future they might be applying for community Medicaid and they need services, now may be the best time to investigate it instead of waiting until the law changes and it becomes more difficult to become eligible for benefits. So this is a big flag up if you know anyone who might need these this program for community Medicaid. And we're not quite sure how they're going to implement it yet because it's a moving target. So we will see. So I told you all of this already. No penalty currently for home care applications. That is what the takeaway should be for this. Are there any questions?
What if your kids are already on all your bank accounts? How does that work?
So when you have joint accounts, Medicaid considers the Medicaid applicant as the owner of the account, unless you can show the deposit slips from your daughter depositing her paycheck into your account. So that does not protect assets from Medicaid.
Okay, and what about if they're all on the house? If they're, you know, the deed's in their name also?
I think that is a very poor idea. They don't own the house. If your name is not on the deed, you don't own it. But giving away the house to your children is a poor idea for a variety of reasons. Number one, you may have the most trustworthy, wonderful children. I know I do. However, kids sometimes make bad decisions. Sometimes they go bankrupt. Sometimes they get divorced. What was your asset? If it's their asset, it gets lost in a divorce proceeding. It gets lost in a bad business decision. Or they want to sell the house. They don't think you should live there anymore. The other issue is a tax issue, which is, because if you take your house, let's say you bought your house in Long Beach, and let's say you paid years ago and you paid $300,000 for it, and it's worth $600,000 today. If you die owning that house, your children inherit it with the basis of $600,000 and they pay no capital gains taxes because of the way the tax law is structured. If you give the house to your daughter, she takes it with a basis of $300,000 and she's going to pay capital gains taxes on that house of $300,000 on $300,000 because that's the gain. So she's going to be paying a lot of money in taxes. When you take the house and instead of giving it to your child, you place it in a trust, your creditors can't get to the house, your children's creditors can't get to the house. And at your death, if that's what you want, your children inherit your house. And the house can be sold and the money is protected, which can happen also. If you start giving it away, so it's not something that I ever recommend.
Okay. And what about if they inherit the house, right? Or wait, if it's in a trust for them, will their spouse be able to take it?
No, because they don't own it. They can act as the trustees. They act as the trustees while you're alive. When they eventually inherit it, it depends upon what they do with it as to whether the spouse is going to get it, but it's totally protected in the trust.
Okay. See, I have a little bit of a problem. Okay, so I actually bought a house for my son, but it's in my name, but it's going to be his. So he's going to buy it from me, but I don't really want the money for it. Okay, I want him to, yes, I know I'm going to be trusting him, just pay me off monthly because I don't really have a pension. So my husband doesn't. I mean, I do a small one, he doesn't have any, so.
Yeah, well, so you need some kind of contract with him. You need a
Right.
mortgage.
Promissory note or,
Yeah,
don't-
you need to have some kind of written agreement that he's paying you. He's buying.
right, he's buying it for what I paid for it. It's kind of hard to explain, like, I don't know how to do it, so I guess,
You need to consult with somebody and get some advice as to what to do.
yeah, I know.
Give you one on this call. But you need to have some paperwork that documents what happened.
Okay. All right, thank you.
Okay? So, and the last component of elder laws is who is going to inherit my assets at my death? And in New York State, there are 4 basic ways we do that. We do that through intestacy, operation of law, last will and testament, or trust. And often it's a combination of these different methods of transferring assets. And we're going to talk about that in more detail if you decide you're going to sign up and attend the next session of the Zoom presentation. So I was happy to provide you with the information. You'll see my phone number and email addresses on the materials. If you have any other questions, give me a call or email me and I will endeavor to answer your questions. I can't answer very personal questions. I can answer general questions. I tell you that. I can't solve your legal problems on the phone. But if you have a question about the presentation, I'm happy to answer it. So thank you very much for
Thank
your
you.
Yeah.
attention. And I hope I was helpful today.
Great,
Thank
thank
you
you
for
so
your
Thank you,
much.
Ellen.
Okay, good night,
Night.
Bye.
this evening.
Bye.
Bye-bye.
Bye.
Bye.